SJC-12137, IBEW Local 129 Benefit Fund and others, v. Joseph Tucci and others.
Good morning, Mr. Leviton.
Good morning, Your Honors. If it may please the court, my name is Jason Leviton. I represent the plaintiff appellants in this matter, IBEW, Local 112, and others. Plaintiff appellants has two main points we'd like the court to consider when trying to determine whether members of the board of directors of a Massachusetts corporation owe fiduciary duties directly to their shareholders. First, I think it's important to realize that hundreds of millions of dollars have been recovered by my firm and our co-counsel, along with other plaintiffs' counsel, from members of boards of directors directly in the merger and acquisition context.
In Delaware?
Throughout the country, Your Honor, throughout the country. If derivative relief, however, was only available, shareholders would not have an effective remedy. In fact, in almost all jurisdictions, including here, derivative standing is extinguished unless there's very few exceptions when the merger closes because of the continuous ownership rule.
Right, but why, since this issue came up quite a while before the closing occurred, why couldn't you seek injunctive relief? I guess I don't understand. I understand the rule that once the closing happens, you're out of luck in terms of derivative actions, but why didn't you do it before?
Well, what I would say, Your Honor, is we filed the suit. The deal closed from the time the deal was announced until the time the deal was closed. We were talking about a year. Injunctive relief is an exceptional remedy that most courts would prefer not to implement. Obviously, both here, Delaware, California, and other places, what the courts generally say is, let the deal close, and if there is...
No, because obviously you've got irreparable harm if it closes. So let's say that the court couldn't say that with a straight face.
Well, when you talk about irreparable harm, what I can tell you that the courts in Delaware say is that irreparable harm doesn't exist if monetary damages are allowed. That can fix the irreparable harm. Irreparable harm comes when it cannot be fixed. It cannot be fixed by monetary damages. In situations like this one, that is just simply not the case.
Can I ask you why you didn't file a derivative action? I don't understand this whole area very well, but it just occurred to me reading through the briefs, why didn't you do that?
Well, there's a few reasons, Your Honor, and thank you for the question. The main reason is they simply cannot be litigated fast enough. In almost all jurisdictions, the reason you would not do a derivative action, there's actually a couple answers. The first is you simply don't have time. In a year, you cannot both file the case or make a demand, because remember, then you have to wait for a certain amount of time, wait for the corporation to create a special litigation committee to consider the demand, communicate with the corporation about its response, file the litigation, and then litigate the case through appeals. And this is a perfect example of that. It just simply can't be done in time.
That's where injunctive relief comes in. That's what I don't understand.
Your Honor, if we had to file, if the courts, I can tell you throughout the country, the vast majority of courts, as I said a minute ago, would prefer you not to do injunctive relief because that kind of stops everything. There are plenty of situations that can happen where the deal can still close, right? Maybe shareholders want the deal, maybe this, maybe that, when the recovery can really solve the overall problem. The other issue with derivative relief, and I think this is important for everybody to consider, is where does that relief go? In a derivative action, the plaintiff stands in the shoes of the corporation, right? The corporation then sues the directors. If there is a recovery, that recovery goes to the corporation. In this case, that corporation would be EMC. When Dell purchased EMC, Dell would end up with the recovery that went to that went to EMC. In neither of those situations do shareholders actually get the remedy under the derivative relief.
Shareholder, don't you basically agree that you're a shareholder, you're not an individual? And whatever remedies or rights you have are rights that you have as a shareholder as against the corporation, not as an individual. I mean, don't you just lose your individual status when you become a shareholder? I mean, I thought that was the way it worked.
Well, you don't lose your status. What you do is you certainly.
Unless there's some special circumstances, which I understand from the briefs, the two situations where individuals can sue on their own behalf. But otherwise, you're part of the group, aren't you?
You certainly are a part of a group, Your Honor. However, you're still talking about personal property. Myself purchases shares of a corporation. No question, that makes me a shareholder. However, when the company does something that affects my personal property, which are my shares, which hurt me, what I think is important to remember is once the deal here was announced, EMC lost almost $6 billion in market cap. Just because you happen to have been a shareholder doesn't mean that it isn't your personal property. I agree, when you look at the Tucci test coming out of Delaware, there is frankly a reason that almost every state follows it. It's because the courts have accepted the true rationale, frankly, that even as a shareholder, it's still your own personal property that is being affected.
But the R156D, Section 8.30, does not say that a director has a fiduciary duty to the shareholders. It says that he or she has a fiduciary duty to the corporation and must consider not only the interests of the shareholders, but also such things as the employees, the economy of the state, the region, the nation, long-term and short-term interests. So isn't your argument premised on the view that their fiduciary duty is only to maximize the value to the shareholders and not to all these other interests which our legislature has said may appropriately be considered by directors?
Respectfully, no, Your Honor. If you look at 8.30, what is important to remember are there are three clauses. The first is it has to be done in good faith. The second is, I'm going to summarize and call it with due care. The third is in the best interest of the corporation. Clauses 1 and 2 relate to shareholders. The way we know that, well, two things. One is the way we know that is if you look at the other part of the statute, 2.02b4. 2.02b4 becomes almost irrelevant if the corporation, if the members of the board of directors owe no obligations to its shareholders. 2.02b4 makes no sense if they owe no duties to their shareholders. In fact, several states have concluded exactly this way. With almost identical statutes, Tennessee, New Mexico, Nevada, Maryland, Iowa, and Minnesota have all concluded based on exactly this language, or nearly exactly this information, or this language, that they do have duties that run to the shareholders. I think the Tennessee decision, which is actually very recent, is very interesting and is absolutely on point. In fact, in Tennessee, the Supreme Court dealt with exactly the same argument that defendants have raised here. And here's what they say, quote, "Question of whether a particular claim is derivative or direct is not addressed by the revised Model Corporation Act or by state statutes governing corporations. So the question must be answered by the state courts." After making that claim, they absolutely reject defendants' interpretation of what both parts of that statute mean.
But do they have the same drafters' comments that we do?
They certainly have the same language. I can't tell you whether or not they have an identical drafter's comments. I can tell you...
Because you don't say much about the drafters' comments, and the drafters' comments, it seems to me, are pretty illuminating.
Well, Your Honor, what I can tell you is defendants obviously put a lot of... again, I think the drafters' comments have to be read in conjunction with the statute. And as I've noted, both 3.80 and 2.02b4 simply make no sense if they don't...
It's not really true, because we've recognized situations where there is a duty to shareholders. It's in a close corporation context and in a public context where there is an oppressive group. So we have two instances at least which would give meaning to that.
You know, Your Honor, I think what's important is to realize, remember, defendant's argument both at the trial court and here was that there are no exceptions.
Well, that may be, but now we have them.
That is certainly true, Your Honor. What I think is interesting, if you look at like the legislative intent, for example, in the Massachusetts statute, is what they don't say. There is absolutely, and defendants put a lot of weight into the legislative history here. What I think is important to realize about the legislative history is it says absolutely nothing about eliminating fiduciary obligations to shareholders. In fact, they point to
Mention shareholders,
it,
other than in the context of the best interest of the corporation under C, under the third prong of 8.30A.
Well, that's true, because the statute itself does that. Again, if we are limited to circumstances in closed corporations and in very small situations, you're already reading language, as defendants say you shouldn't do it, at least the trial court here. You're still reading language into the statute that's not there. I think the most apt reading is exactly what the Minnesota court just did, the Court of Appeals did in Minnesota and also Tennessee, which is to say that you always have these duties that run to shareholders. Now, there are other issues.
Never said that, though.
This court has not said that. Now, I will say, if you look at Chokel,
Like, you could look at Chokel and say that that was dicta at best.
Your Honor, the Chokel court says what it says. We can all certainly read the decision. Chokel is very clear to the point that members of the board of directors have fiduciary obligations to their shareholders. That's what it says. Now, obviously, they do try to distinguish it or say it's dicta. But what I think is also important is if you look at the Coggins decision. Now, the Coggins decision, regardless of how it did or did not come out, that decision could never have gotten to the Supreme Court and could have never gotten to where it was if they didn't owe fiduciary obligations to shareholders.
Wasn't that a pretty small corporation, though? I don't remember now. But I mean, Coggins is in a very different class than EMC.
Sure.
That's my memory.
It's a different size corporation, yes.
It's more on the close corporation line.
Well, Your Honor, but it's still a public corporation, right? I don't think there's a distinction, and I certainly couldn't tell any of Your Honors about a distinction made between a company that, for example, is in the Fortune 100 versus the Fortune 500. I just don't think that's a distinction that this court looks at, or frankly any court has ever looked at. I think the decision rested on the fact that it was a public corporation. And in public corporations, when you purchase shares in a public corporation, you expect the members of the board of directors to honor their fiduciary obligations. And again, that's...
Cases other than Demoulas and Coggin that would have liability go straight to the directors that you're aware of?
I'm sorry, say that one more
In
time.
any Massachusetts cases, other than Coggin and Demoulas?
I think gut gets us pretty close to there, but that's not... I don't know if that answers your question. There are certainly, I can tell you, throughout the years when you look at the litigation, this is the first time defendants had raised this issue in a similar circumstance.
They had the whole process took about 10 months, as I recall. 98% of the stockholders were in favor of the sale. I go back to the question that's being asked, why couldn't there have been a derivative action against the corporation saying that the sale price was inadequate 10 months, 1 month into this 10-month process?
We cite too, I believe it's a treatise in our paper saying that the average closing price, the average deal closes just simply too fast for that to be done. What would have to happen is you would have to move for an injunction. Defendants, which is what they do in every jurisdiction, when you move for an injunction, their answer is there's no irreparable harm, Your Honors, because monetary damages simply flow from it.
But how, that's what I don't understand. Why do monetary damages flow from it if the state follows the rule that we do, which is that your rights as a shareholder terminate upon the sale of the corporation?
Well, Your Honor, the problem when you do that, when the sale closes, right, and you're extinguished, your interest in the company leaves. Again, as I noted earlier, it's important to realize where the monies go. If we had brought a derivative action and we had received $1 billion, right? They already had what this deal was going to close for, right? Dell had already said, we're going to give you X dollars, right? $100 a share, whatever the number is. And they say, okay, we'll take the deal. We bring a derivative action, right? We get a $1 billion recovery out of that derivative action. That deal price doesn't go up. What ends up happening is that deal, that $1 billion, goes to EMC. When they're purchased by Dell, Dell gets that money back. There is no pass-through going to shareholders. So even in the significant, in a significant recovery situation under a derivative action, the shareholders still get nothing. Who gets it is the purchaser, and that just simply isn't just.
And you have cases that happens in? I mean, I would think you'd have to undo the deal and redo it again.
Well, Your Honor, I can tell you that's almost impossible. In Delaware, what they call it is unscrambling the eggs. And you're talking about a massive, massive corporation, billions and billions of dollars.
Yes.
This deal has closed. To unscramble those eggs today is simply not possible.
Can I just ask one question?
Of course.
Why isn't your suit precluded by Section 8.30, given that it provides a complete defense to directors who are acting in the best interest of the company?
Well, because our position, Your Honor, is that it wasn't in good faith. Also, those are a lot of, I mean, if you actually look at the complaint itself, there are significant allegations on the wrongdoing that we allege against Mr. Tucci, and for example, about how he was trying to benefit himself over other shareholders. That is certainly not good faith. It's also a violation of the duty of loyalty, which is why it can't be exculpated. But most of those are fact questions that will be left for a jury.
And what is it that you're expecting to have happen if you're saying you can't unscramble the egg? It's happened, right?
It is exceptionally rare, and I actually can't give you an example of any time the eggs were unscrambled. It's just not possible.
Well, what's going to happen here?
Monetary damages will flow to the shareholders. We would sue if Your Honor sent it back for for remand to the district court. We would litigate the case. There would be summary judgment. There would be a trial. And the damages that came from that, or any settlement, would be given to shareholders, not to EMC, which again, or Dell, which again, like I said, it just simply doesn't make sense. The idea that there could be wrongdoing at EMC, who would then receive the funds, who would then, after the purchase, it goes to Dell, just doesn't make any sense. The wrongdoers under that circumstance, under that situation, would be the ones who got the recovery. I just can't understand why that would make any sense.
Let me ask you a question here that I think you drew to our attention, which is that there seem to be two issues regarding your claims. One has to do with whether or not there is a fiduciary duty running from the directors to shareholders. And the other, I think, is one which deals with the type of harm that you allege affects your personal rights, or whether the harm is suffered by shareholders generally. And do you agree that Stiegel versus Ladner, coming out of the District Court of Massachusetts in 2005, correctly reflects Massachusetts law in that regard?
I think, yes, I think it does get us.
Okay.
I think it does get us closer there.
The inquiry there is one that I think that Judge Liepensberger basically ultimately rested his decision upon, which is that the harm that you're claiming is a harm that is suffered by all shareholders equally, and therefore you lose.
Your Honor, the problem when you divvy it up as are all shareholders equally harmed is, again, this problem of just because everybody was harmed similarly doesn't mean that they weren't harmed personally. Here, everybody was harmed personally. Again, this is
Personally in the same way.
Sure, but this is precisely the reason that the majority of Supreme Courts around different states, especially Delaware, remember, there are many decisions, I could have cited 100 decisions of different Massachusetts courts saying, look, or courts around the country that say, look, the court that looks at these things the most is Delaware. Therefore, we look towards Delaware for instructional purposes.
Have we ever said that?
Has the SJC said that? I don't know the answer to that.
But Delaware doesn't have the Model Business Corporation Act.
That's true, Your Honor,
It's
but
common law in Delaware, isn't it?
absolutely true. But that's not the same for Tennessee, New Mexico, Nevada, Maryland, Pennsylvania, Iowa, and Minnesota. Tennessee, all of those state Supreme Courts have, actually Minnesota is a Court of Appeals decision. Those cases either have identical language to ours, which is both 8.30 and 2.02b4, that come down solidly in favor of my client's position here. But Iowa, Tennessee, and New Mexico are absolutely signers of the MBCA. And there, they have rejected defendants' position outright.
Okay, thank you.
Thank you.
Good morning, may it please the court. Thomas Doherty for EMC and its directors. I'd like to take a moment and list 4 factors that I think are fundamental to the decision, and then the decision that Judge Liebensberger made, that the applicability of 830 and 7.4147 is such that this is a derivative action under our statutes, and nothing but a derivative action under our statutes, and then go through 830 and 7.4147. And first, and this responds to some of the questions, EMC is no argument, a widely held, publicly traded New York Stock Exchange listed company with 10 out of 11 directors who were leaders of other companies, independent directors. It is not a closely held corporation, nor a Coggins situation, which is a controlling shareholder situation. In each of those 2 situations, you could call it Demoulas, you could call it Coggins, there are special fundamental duties shareholder to shareholder based. They are shareholder to shareholder based. They are not director duties under our statute. They're additional duties. And we never argued that there were exceptions. We argued that the statute is what it is, but there are those different duties. And that's why there are direct causes of action, shareholder to shareholder, against directors of close corporations or Coggins-controlled situations.
Well, go ahead, I'll ask you later. Go ahead.
Next, all shareholders did receive the same consideration here. And very importantly, third, all shareholders received full information. There was no misrepresentation claim, which would be a direct claim, and received full information with which to make that vote, which what happened to be 98.4% of the voting shareholders in favor. That proxy statement issued in December, iterated all the way through the process until July, not only specified the terms and conditions, but the go shop and the process. And the shareholders had the benefit of that information in considering whether or not to make a demand.
But what do you say about the argument that really seems to be of concern, which is that it's simply not possible?
Yes, yes. Let me get there. It's entirely possible. What happens, first of all, under this statute, there is a single duty to act in the best interests of the corporation. That duty was enacted in an act related to takeovers, dealing with mergers.
What do you mean it was
legislature had mergers in mind in doing that.
How do you know that?
Because it says so in this title of the act and in the commentary to the task force comments. The provision, which is called the constituency provision, which says that, as the Chief Justice quoted, that the directors may take into account the interests of the employees, customers, suppliers, the Commonwealth, and the long and short-term interests of the corporation and its shareholders.
In EMC's case, aren't a lot of the employees also shareholders?
Yes, and one of the benefits of this merger was that the headquarters, as is alleged, of the combined companies, which benefits the employees, the customers, the suppliers, the Massachusetts economy, and the shareholders for the enterprise storage and data management business, is here in Massachusetts, a $25 billion annual business, and that benefits all those constituents. The most important thing I have to say about this provision is that it's comprehensive. It says that the directors shall not be liable if they perform their duties in compliance with that statute to be acting in the best interest of the corporation, and there is no duty to act in the interest of shareholders alone. This is not Delaware. Again and again in the task force notes, you'll see that the statute was specifically enacted to differentiate this state from Delaware.
But what do you say to the argument that, put Delaware aside, New Mexico, I forget all the states, Iowa,
Yes, I have it.
that have the same statute, or
No.
virtually, they
Right.
don't?
So in our brief, we went through, for example, Mexico says shall. You shall take into account the shareholder interest. It is very different from Massachusetts. Secondly, Tennessee. They put that in the reply brief. We didn't have a chance, therefore, in writing. It cites the Keller case. First of all, the Tennessee statute is completely different. It doesn't have 7.41 through 47, which I want to get to in 1 minute. And the Keller case, which is the Supreme Court case of Tennessee, it says in a section of the case, headed duty owed, first paragraph, Massachusetts is different from Delaware and Tennessee, because in Massachusetts, the duty of the director is owed to the corporation, not to the shareholder. That's Tennessee itself distinguishing this situation. So let's get to this question of unscrambling the eggs and irreparable injury.
Let's maybe do it even in a hypothetical. So the plaintiff is saying there's just no way you can bring a derivative action when this is going on. Even if 98% of the stockholders were opposed to it as opposed to supportive of it here, that a derivative action wouldn't work. The corporation would come rushing into court seeking an injunction. Why isn't that true?
It doesn't work that way. With all due respect to the plaintiffs, Your Honor, the statute is robust. It provides a mandatory demand in all instances on the corporation to take action. The corporation can either have a committee to look at whether or not to take some action to change the process, to add to the go shop, to change some aspect of the process real time. And the court has an accelerator and a brake. Under the statute, it can accelerate the review of that process, or it can actually delay the closing, so that you don't have to, with an appropriate showing, so you don't have to unscramble the eggs or provide for damages to be later recovered. But that was done in connection with the duty being to the corporation as a whole, as a mechanism for essentially allowing the shareholders to make, any shareholder can make a demand. 1.9 billion shares, only takes one share, one shareholder, postage stamp, you make a demand. Doesn't have to be articulate. And then you could have, for example, as in the Solomon case, which this court pioneered, a disinterested shareholder vote. We already had an annual meeting. We already had a special meeting on the merger. The disinterested shareholder vote could say, do you want to sue these directors for some aspect of this process? If no, that's the end of it. If yes, you commence it, and it's under court supervision, and the court has that accelerator and brake. It's an expedited case in the business litigation session. It would occur. So I think it's both hypothetical, because they never made the demand, and they're obligated to, and no one did. I think perhaps they supported the merger, and they thought that the process that they were reading about was good. In the Billings case, there would have to be, in order to upset, right, the lack of standing once the closing happens, there would have to be a transaction undertaken for the purpose, and deceptively so, of ousting people from their standing. This is the opposite of that. This was perfect transparency along the way about what the process is, and every opportunity of anybody to challenge it, subject to the court having that accelerator and brake to address it. So having never tested the process and never made the demand, nor expedited this appeal, by the way, which they could have done, the process is structured so that in no more than 90 days there is a review, or 120, even if not accelerated. There were 330 days here. They should have made that demand, gone to the business litigation, and then after the determination, if the determination of the shareholders was, sorry, we're not suing about any directors about any aspect of this process, it's done. If it was, yes, there's a piece of the process that needs to be revised, it either gets negotiated or it gets litigated, and the court has those two mechanisms to deal with it. So I think that addresses that. I don't have anything, I think, further other than to say the Tucci test. I'm sorry, Delaware does not have our statute, and Delaware is trying to balance two interests, serving two masters, a duty to the corporation with a duty to the shareholder. There is no duty to the shareholder to be balanced here, the shareholder alone, because the duty is to the corporation, and it's the directors who have that duty to balance those interests here, right? Which is why I mentioned the headquarters and the benefits there, right? And as to the price, there's a fully informed vote, and the shareholders accepted that price atop that process. So
What about the question that I put to your brother about this being like two issues? And you really address only the first, it seems to me, which is that there's no duty owed by the directors to the shareholders. What about the second part of that, assuming that you are in agreement that that's a correct statement of the law, the one that Judge Liepensberger really rested his decision on, which is the type of harm that was suffered?
As I said, here, all shareholders receive the same consideration, and that consideration is
Is that
itself.
alone a basis for affirmance?
Is that alone a basis for affirmance? No, I think that the basis for affirmance here is that there was a derivative action that was essentially labeled a direct action that wasn't, and they needed to make a demand and let that process fall out.
Why isn't it enough to do as Judge Liepensberger did?
I think he agreed with us that there was a requisite element here that they need to make a demand because this is a situation where the duty is to the corporation. And in this instance, with everybody receiving the same consideration.
Isn't that sort of dispositive for him about why there is no duty here?
I didn't hear you.
Isn't that sort of dispositive as I read Judge Liepensberger's decision? The fact that the type of harm suffered here is the same by all shareholders really drives the decision that this is really not a...
I think there are probably at least two drivers to the decision then. There's no question in my mind that this decision is driven by the fact that the duty is owed to the corporation and that it's necessarily, you don't serve two masters. He even said, quoting the book of Matthew,
No,
right?
but I think he said, I don't think that there is that he didn't buy your argument that it's the corporation always. At least as I read it, you have to look at the case.
So, with all due respect to Judge Liepensberger, what we said was there are two situations in which there are direct duties by shareholders, Coggins and close corporation. And so you can call them exceptions or whatever. We just called those different situations based on shareholder status. And I think Judge Liepensberger characterized that a little differently, but I think fairly that was our argument. That's our argument now. And that's the reality, too.
Because in those cases, there is a duty to the corporation
So,
in a closed corporation, but also a duty to minority shareholders.
yes, and so, for example, you could have a derivative action in a closed corporation case if someone ran off with some money and it needs to be recovered for the corporation. That could be a derivative and a direct action. In any event, you can have both in a closed corporation or in a majority-controlled corporation. But in a widely held corporation under this statute, no, the duty is owed to the corporation by the directors. And as to the question about the valuation, that valuation of the company is essentially the per-share valuation that the shareholders receive.
Now, pragmatically, in those states which do it differently, what happens with regard to mergers and acquisitions, both those that are made and those that are where the corporation decides not to make those deals?
Significant expedited proceedings, significant resources by the court and the parties to present the matter for resolution on process, if it's derivative, on price, derivative, all. And there are direct claims in Delaware which we would call not appropriately direct, but the process in either case gets expedited so as to reach a resolution sufficient that the process itself is no longer challenged. It is sufficiently understood. There's clear disclosure, and to the extent possible, the closing is not delayed any more than it need to be if there's appropriate showing of a need for that. So it's all expedited. Again, you know, the cases are innumerable that the court then unfortunately has to spend more time, as do the parties, more quickly to expedite.
Okay, thank you.
Thank you.